Okay, so good afternoon, everyone. We have folks joining us all over the country today. I want to give you a big thank you to all of you for attending our kickoff webinar series. We're honored to be in such great company today to help facilitate this webinar. Our first topic today is how telemedicine can help, understanding the regulatory and clinical implications of telemedicine abortion in the post-Dobbs era. So without further ado, I'm going to hand it over to our presenters. We have Hnelson today and Dr. Elizabeth Raymond, and I'll let them do a quick intro of themselves.
So I want to welcome everybody also. This is Hnelson. I'm the managing partner of Nelson Hardiman. We are, just as background, we're a healthcare life sciences law firm. I'm the founder and the managing partner of the firm. For today's purposes, the context of the decision to hold this webinar and my presentation has been experience over the last 20 years working generally in telemedicine, on telemedicine regulatory issues, both dealing with issues that arise with state medical boards and other licensing authorities, state pharmacy boards, as well as guiding telemedicine ventures. And from my perspective, the webinar today is going to be an effort to apply that knowledge forward. And I'm really delighted to be joined by Dr. Elizabeth Raymond.
Hi, everyone. I'm Beth Raymond. I'm a scientist at Gynuity Health Projects, where I've spent the past 12 years conducting research on medication abortion. The overall aim of my work has been to develop and evaluate procedures to increase access, enhance patient autonomy and comfort, and reduce cost. And my recent projects have focused specifically on the safety, effectiveness, and feasibility of providing medication abortion using telemedicine. And I'm very happy to be here today.
So a quick overview today of our webinar series. Like I said, today is a kickoff of a three-part series we'll be hosting over the next several months. This is just the first few parts, as I'm sure we're going to keep peeling back this onion and have a lot more to dive into. So again, thank you all for joining, and we have a lot more that just joined us. So we're going to be facilitating these important conversations that will provide guidance and solutions to our providers, our patients, advocates, and all people who are engaged in access-related activities. So we really hope you'll join us for part 2 of our webinar on July 20th. And part 3 of the webinar series on August 17th, we'll do a deep dive on the regulatory questions in prescribing and dispensing mifepristone, and then get into the litigation risks at hand for patients, providers, and again, people engaged in access-related activities. So in the interest of time, we may reserve more detailed questions for future programs and after this session, and I will let you take it from here.
Thank you. And just I want to add, we are going to make this presentation available as a recording, so it will be available after. And we also are receptive to your thoughts about future programs where we might be able to contribute healthcare regulatory or telemedicine specific expertise. So please don't be shy. We're very open to extending this, and it's helpful for us to hear from the community of providers dealing with these issues what is coming up and to share information. So with that, I'm just going to give a quick overview of today of our program. We basically broke our program today into 5 sections. The introduction is just some thoughts about where telemedical abortion fits into the current conversation. We were planning this webinar before the Supreme Court decision, but we want to talk about where it fits in both to the post-Dobbs, post-Supreme Court decision era, as well as to the evolution of telemedicine laws. The telemedicine restrictions in a number of states have been developing over the last few years, and we want to talk about that. We are going to, I believe I'm going to provide a little bit of a historical context for how telemedicine has evolved in ways that we think are relevant, and a legal framework for how to think about determining what you can and can't do as a clinician or other type of provider, a pharmacy in your particular state. And Beth is going to provide an overview of telemedical abortion from a clinical perspective, and then we're going to get into some of the legal, regulatory, and practical questions. We're hoping to leave a few minutes at the end for Q&A, and I'll try to pay attention as we're going to questions if they fit into the flow of our program. So there is a place to add them if you have questions as we're going. Just a disclaimer, we're offering this webinar for educational purposes. Nothing said in this webinar should be relied upon as legal or medical advice. The opinions we're expressing today are our own and not opinions of any organization we're affiliated with. And of course, any individual listening today who's trying to decide what to do, whether in a clinical situation or a legal situation, is encouraged to speak to a professional directly about that particular situation. So with that, we're going to jump into situating today's conversation, telemedicine, abortion, and the present moment. So, as I mentioned a minute ago, telemedicine abortion, telemedical abortion was already becoming a divisive issue before the Dobbs opinion was leaked in early May, and certainly before the decision was released last week. The issue in many ways has been driven by clinical changes in abortion and that we're going to talk about, and the extent to which medication abortion has really changed abortion. And as I'm going to talk about in just a minute, we've been living through the last 2 decades, and particularly the last 5 years, a sort of massive, a rapid acceleration of expansion of access to telemedicine, and that had precipitated some resistance to telemedical abortion even before these court decisions. It's very clear that the Dobbs decision is accelerating legislative and regulatory change, both as to abortion access generally and as to our subject today of telemedical abortion. So this is a moment of rapid change and confusion. I want to ask your indulgence. We're not going to do a state-by-state particulars today. We're saving that for July, just because there is so much dust being kicked up by all the activity. And I want to say both here at the beginning and at the end that we part of our decision to do this program today is a belief that as a matter of public health, it is absolutely critical to disseminate accurate information to patients, to providers, to everybody about medication abortion and about telehealth. And that was really a priority that drove our decision. Beth, I don't know if you have anything to add here. So I'm just going to, just as a kind of some early thoughts about the decision, what we're going to talk about today are risk constraints imposed by state licensing. The overall framework in the United States is that states regulate the practice of medicine and all other health professions, as well as the practice of pharmacy. And we're going to talk about the distinctions. And we want to talk about the risks. As a practical matter, just to say the obvious, the state licensed clinicians their licenses allow them to prescribe in the case of clinicians and to dispense in the case of pharmacies only in those states that permit the activity. And we will talk about the risk associated with abortion prohibitive states. We do expect part of what's fascinating about this moment in time is that there are a number of non-clinician actors, organizations, advocacy organizations, for example, both within the country and internationally, that are providing medication and doing so at a greater distance and less regulatory reach. And so that's an important piece of this conversation that's not a typical telemedicine question. Also, the question of the FDA status, we included on this slide the immediate comments coming from the administration after the Dobbs decision related to the FDA's, the objection to limiting access to a medication that's approved by the FDA. And one of the fascinating things that we're going to talk about today is the specific status of mifepristone as a medication, the REMS, that is the risk evaluation and mitigation strategies that are imposed specifically on medication abortion, whether the FDA is going to change those, change the requirement of a certification of prescribers, prescriber agreements and patient agreements, which would reduce the risks, And a big question, which would take much more activity, which would be to ultimately consider shifting the status of mifepristone from a prescription medication to an over-the-counter medication. How that would happen, what that would mean. We're not going to get into those details, but I want to put it out there because I think this is kind of an intertwined, bigger question, and likewise a question that I've been pondering for this last couple of weeks, which is the question of medication coming into the United States, raising issues under the Food, Drug, and Cosmetic Act. As a practical matter, we have lots of examples of medications, versions of medications that are approved in other jurisdictions and other countries that are not FDA-approved versions that do come into the United States, and effectively whether that simply is going to become a means of access that is safer for providers and unpreventable. So these are just large questions hanging over our presentation today that I wanted to put out at the outset. With that, I wanted to turn over the program to Beth to take us through some, oh, sorry, I apologize. I'm going to talk first just briefly about the recent history and legal framework of telehealth. So I mentioned that the last 2 decades have been a time of profound change in telehealth. And I think what's important to say here is that mifepristone is a very different kind of medication, right? It's a medication that's not taken chronically. It's taken for a specific instance to abort a pregnancy. It's very different than medications that have driven much of our recent telehealth history, particularly controlled substances. But I think it's helpful just to take, if you'll bear with me, a couple minutes to go down memory lane in telehealth, because I do think it shapes the conversation that we're having today. The earliest telehealth, and I'm excluding robotic surgeries and some teleradiology, on a massive commercial basis in the United States was the launch of Teladoc in 2002, which remains the largest telemedical provider in America. What was interesting was the early 2000s were a period when telemedicine began through an explosive growth of internet pharmacies. And what happened was a boom period where controlled substances were being made available along with other medications in a way that was considered very loose. And it led to a massive crackdown, culminating in the Ryan-Haight Act in 2008. I think this history is very important. It was a period where essentially the possibility of internet access and information led to access to medications. There was not care taken about doing it in a clinically rigorous way. People could click through in a matter of seconds and get access to controlled substance medications. And so that led to this crackdown. And the relevance here is that there's a legacy of suspicion in telemedicine about questionnaire-based care, and we'll talk about different modalities of telemedicine. And there's a negative perception that continues to hang over certain kinds of telemedicine that are perceived as being for convenience, as opposed to people who wouldn't otherwise have access. And I think that's important to remember because we're dealing with regulatory agencies on a state-by-state basis that often have a kind of binary approach to telemedicine, where they see some telemedicine, for example, making care available to people in rural areas who wouldn't otherwise have access to a specialist, as important access, but a little bit of a suspicion about telemedicine that's merely for convenience. As I mentioned, 2008 was an important change in telemedicine because the Ryan-Haight Act eliminated telemedicine for many categories of controlled substance prescribing by imposing in-person requirements. And it really gave the DEA a grip on telemedicine. And what happened over the last 10 years has been a significant amount of progress in harmonizing state-by-state laws, which are very different on a whole range of issues. Can you establish a provider-patient relationship, right? It wasn't until just a couple of years ago that Texas was the last state to get rid of the old rule that you couldn't establish a doctor-patient relationship, a new one online. You had to have a in-person relationship, right? Changes around whether informed consent to telehealth is required. We're going to talk about this, but reducing the limitations on where the patient can be, what we call the originating site in telehealth, and those restrictions have gone away, and a significant expansion of modalities beyond real-time synchronous video. And we'll talk about that, but it's important to remember that we're only 5 to 7 years into a period of rapid change where asynchronous telemedical delivery was not even an option. And then finally, two last points before we get into our specific topic today. The pandemic was a real game changer for telehealth, right? The level of telehealth usage increased by over 8,000% in the early months of the pandemic and has leveled off at over 4,000% more than was being used in early 2020 before the pandemic. It has represented a massive shift in patient attitudes towards telemedicine and provider attitudes, and really taken us into a new era of telemedicine. And as a final comment, in terms of the big picture of what's going on in telemedicine, there are a whole series, even before abortion arose, of emerging issues, questions of avoiding fraud in telemedicine. How do people in government programs and insurance and private insurance access telemedicine? What coverage do they have? And big questions that are going to be relevant to our presentation today of how much can we rely on patients to self-screen? How much do we need to do identity verification? These are all issues that, again, predate the conversation around telemedicine abortion, but we're percolating up as a result of the very different ways that telemedicine allows patients and providers to interact online. I want to just say a word about how do you actually determine, if you're a clinician, what you can and can't do via telemedicine. And so you have to, unfortunately, our system does not make it easy, right? You have to look at certain federal laws, certain state laws, and of course, if you're in an environment where you're getting reimbursement from a third party, at payer requirements. So just at a high level, to provide a framework, that one of the comments that we've gotten has been that shouldn't there be just one place where I, as a clinician, can go and find out whether it's okay to do this particular kind of telemedicine in this place? And the reason that it's not is essentially all the categories of relevant sources of law on our slide. At the federal level, it starts with the FDA. What is the status of medications? What are they approved for? Can they be used off-label? They dealing with, in this case particularly, and in other about 6,000 drugs, the issue of REMS, risk evaluation mitigation strategies that impose specific limitations or particular training or agreements that doctors and patients need to sign, and limitations that the FDA puts on use. And we're going to talk about those. At a federal level, it's important to always look at privacy and data security constraints, which are an important compliance issue for telemedicine. And in the area of controlled substances, not relevant to today, but when you talk that the DEA is a relevant place to look. At a state level, when you go to look at state laws, the central destination that we begin with is, in practical terms, is looking at the state licensing agencies for whatever category of clinician, and particularly with prescribing state medical boards, which authorize physicians to practice medicine and to prescribe, and are the enforcement agencies that police licensing and impose discipline up to and including revocation of physician licenses. We also have specific state laws and regulations relating to what is permitted in prescribing, what is permitted in dispensing, which is usually but a pharmacy activity, but also something that physicians have rights to do that differ from state to state. What modalities of telehealth are permitted in that state, and we'll talk more about all these topics. What is the scope of practice for non-physician personnel like nurse practitioners? When it comes to dispensing, we have to look at pharmacy board requirements and, of course, privacy and data security issues at the state level. So these are all the categories of places to look to determine if a particular activity is permitted. And again, in our July webinar, we're going to get into much more of the detail for abortion-specific and medication abortion via telemedicine rules from state to state. So with that, this time I'm going to turn it over to Beth to provide a kind of clinical overview of telemedical abortion.
Well, thanks, Harry. I know that many of you listening have been working in abortion for a long time, but for some, this is a new area. So I'm going to quickly review some basic information about the clinical aspects of abortion, medication abortion, and give you a little history. Medication abortion is the use of medicines to essentially induce a miscarriage. Medication abortion is mostly used within the first 10 or 11 weeks of pregnancy. The standard treatment regimen, it uses 2 different medicines. First, the patient takes mifepristone, which blocks the hormones that allow the pregnancy to develop. Then within the next 48 hours, the patient takes a second drug, misoprostol. This is a medicine that was initially approved to treat stomach ulcers. Misoprostol induces uterine contractions, which expel the pregnancy. Patients may take the mifepristone either at the provider's office or at home, and in this country, it's standard to take the misoprostol at home. This treatment is highly effective. More than 95% of people using it within the first 10 weeks of pregnancy have a successful abortion without the need for any more treatment. About 5% need either more pills or uterine aspiration if the pregnancy doesn't end or if they have heavy bleeding. It's also very safe. Almost all patients have bleeding and cramping. That's the medication working. And many have other symptoms like nausea or dizziness. But serious side effects that require hospitalization or blood transfusion, for example, are very rare, occurring in less than 0.5% of patients. Medication abortion is much, much safer than having a baby. Next. Next, Carrie. Mifepristone was first approved by in the United States by the FDA in the year 2000. Since then, the proportion of abortions that are done medically instead of through a procedure has steadily risen, and medication abortion is now the most common abortion method in the United States. Next. Mifepristone has an interesting regulatory history. When it was first approved by the FDA in the year 2000, the FDA placed certain restrictions on its distribution, supposedly to ensure safety. A key restriction was that mifepristone would not be available in pharmacies. It could not be mailed to patients. It had to be dispensed directly to patients only in clinics, medical offices, and hospitals. Consequently, to provide a medication abortion, a clinician had to order the pills in advance to be sent to the clinician's office so that when or if a patient arrived who needed an abortion, the clinician could hand them directly to the patient. This sounds trivial, but it really can be a barrier to provision. Notably, there was no requirement that the patient had to actually take the pills in the office. How exactly this ensured safety was never very clear. But anyway, this rule meant that the patient had to come in person to the provider's office to get the drug. And that kind of inhibits the use of telemedicine to provide this service. During the pandemic, as a result of a court case, this rule was lifted. Actually, it was lifted, and then it was reinstated, and then it was lifted again, and then finally in December 2021, FDA announced that the rule would be permanently eliminated. Next. Actually, up until recently, there were also clinical reasons that patients needed to come to the office to get medication abortion. This slide shows the criteria that clinicians typically use to determine whether a person is actually eligible for this treatment. As you can see here, it's appropriate for people who don't have certain medical conditions, who are no more than 10 or 11 weeks along in their pregnancy, and whose pregnancy is in the uterus. Sometimes pregnancies implant outside the uterus. That's called an ectopic pregnancy. And medication abortion is not known to be effective in that situation. In addition, until recently, clinicians believed that certain patients, specifically those with a negative blood type, needed a medication called Rh immunoglobulin, or RhoGAM is the common name, to prevent a serious condition in a subsequent pregnancy. Next. Now, these medical conditions here are normally assessed by interview, just asking the patient, do you have this or that or the other? And that obviously can be done by telemedicine. Next. But determining whether a patient meets these second 2 criteria was thought to require an ultrasound or an exam, which obviously have to be done in person. And determining whether a person is Rh negative requires a blood test, and RhoGAM is administered by injection. So again, that requires an in-person encounter. Next. So the use of telemedicine to provide medication abortion was pretty limited given this clinical situation. In the late 2000s, some clinics began using a site-to-site telemedicine model in which the patient was in one clinic and all the tests were done, and the clinician was in another, and they communicated by video conference. This was actually quite helpful because family planning clinics don't necessarily have a doctor on site all the time. So this model could enable patients to get care even when the doctor was elsewhere. In 2016, my organization, Gynuity, initiated a research study to provide abortion by direct-to-patient telemedicine. It was a study, and so therefore we could get a special dispensation from the FDA to allow study sites to mail mifepristone to patients. So in this model, the patient communicated with the doctor from her home by video. She did have to go to a medical facility to get the ultrasound and the blood test, but it didn't have to be an abortion clinic. The doctor would review the results of those tests, and if all the criteria were met, the doctor would send the medications to the patient by mail. This worked out really well for many women because it's often easier to get an ultrasound from a radiology office and a blood test from a lab than from an abortion clinic. There's a lot more radiology offices and labs around, and they don't typically have protesters harassing you when you try to go in the door. So we conducted this study for 5 years, and we enrolled thousands of patients, and we didn't have any significant problems. Next. Meanwhile, research scientists were researching, and we discovered some important things. First, it turns out that Rh-negative women apparently don't actually need that ROGAM if they're having an abortion very early in pregnancy, during the time when medication abortion is used. Second, we can assess pregnancy duration and location pretty reliably without an ultrasound, just by asking the patient about her last menstrual periods and such. And finally, data from other countries in which clinicians were providing medication abortion without ultrasound or exam and then mailing the pills directly to the patient indicated that this approach was quite safe. Next. So in the year 2000, the pandemic hit. And suddenly it became really important to minimize the need for patients to go in person to a clinic. So all the organizations that produced guidelines for abortion, you can see them listed here: the American College of OBGYN, the National Abortion Federation, Planned Parenthood, the Society of Family Planning. They all reviewed the data that the researchers had been researching, and they determined that, in fact, this no-test approach to providing a medication abortion was entirely acceptable for some or most patients. They all revised their guidelines to allow this. In addition, as I mentioned before, due to this court case, the FDA's prohibition on mailing of mifepristone was lifted. And the result of these two changes was, and is, that fully remote abortion care became possible as a routine standard clinical service. Patients can now get medical abortion without leaving their homes. Over the past few years, abortion providers have increasingly begun offering this option, and several new online services were launched that provide only this option. It's really been amazing, one of those unexpected silver linings of the pandemic. And then on Friday, the Supreme Court decided that abortion is not a right guaranteed by our US Constitution. Next. So now abortion is, or soon will be, entirely or almost entirely banned in some 21 states. 40 million women will have no access to legal abortion in their state. In the other states, the situation varies. Some states fully respect and support women's autonomy in deciding whether to have babies. Other states have not banned abortion, but do have legal or regulatory restrictions that limit abortion access. Physician-only laws, for example, waiting periods, specific informed consent requirements. But there is hope. As I understand it, some states are already moving to remove their restrictions. Some are expanding funding for abortion. Cost is a key barrier for many patients. Providers in some, what we call hostile states, are planning to move their clinics to adjacent states so that they can still serve their patients. And lots of effort is going into establishing novel provision models that can facilitate access for patients in both permissive and hostile states. Next. And telemedicine is going to be key to everything. It makes abortion cheaper and faster for patients. It eliminates the need for travel. It can enable clinics to expand their reach to patients, both within permissive states and to people in hostile states. And if we're created, it can really be the basis for new novel methods of care. So it's important that we understand the rules for providing medical abortion care legally by telemedicine. What's required? What are the limits? How far can we push this technology to protect and expand abortion access in our new world? And now Harry's going to explain all that to us.
Okay, thank you. So, so we're going to jump into practical, legal, and regulatory questions relating to telemedical abortion. There are a lot of maps that are being circulated, and this is not one that's creating some of the differentiations that are important to understand. But we wanted to provide at a broad level, based on our tracking of various laws, like where providers today can safely provide telemedicine abortion, which states are currently permitting it. The states that we have labeled in purple, which are actually 26 or 27 states, this is a quickly changing map, are states in which you have one or more of the following: either a ban on abortion or some significant early limit on abortion access that resulting from the Dobbs decision, a specific provision either in the law or regulation of the state limiting mifepristone specifically within that state's telemedicine regulations, saying essentially telemedicine works for everything else but not mifepristone. States that are imposing not bans on abortion, but in-person dispensing requirements or in-person counseling requirements that negate the ability to use a purely remote telemedicine encounter, and states also that have waiting periods as a restriction. So looking at this map, that is 20, I believe actually 27 states where those restrictions exist. As I mentioned in our July webinar, we intend to really dive deeper on these restrictions and where there are options and into some of the more specific issues. But I wanted to use the next 15 minutes or so to take you through some of the core telemedicine principles that we think that are sort of how we think about these issues. So I mentioned this earlier, but I want to really stress that there's two different questions in a telemedicine encounter that leads to a medication being mailed. The first question is, who can prescribe? Is the provider licensed in that jurisdiction? And is the are they authorized to provide the service where the patient is present? I have another slide, a separate slide on patient location, but I think this is really a critical issue to understand. We're going to cover it more on the other slide, but the core idea here is that the patient is deemed to be present. Where the patient is located drives the licensure that the provider needs. The patient's location is the site of practice, and we will talk in a couple minutes about the situation of patients traveling or patients who are temporarily in a different place. Also, for nurse practitioners and physician assistants, what level of supervision or scope of practice is allowed. I should note that several states have limited mid-level nurse practitioner or physician assistant prescribing rights in a way that and that's something we'll cover in July also. Again, dispensing, who can dispense? In all states, pharmacies are the primary vehicle of dispensing under the law of that state. Most states allow for some physician dispensing, but this is actually an important question. Can a physician dispense medication directly to the patient? One of the really hardest questions to answer that we're going to try to tackle in August is what the risks are for providers who are licensed in prohibitive states. Ironically, we're in a situation where ordinarily you would think that being licensed in multiple jurisdictions was what gave a provider more options and more access. But with respect to the new environment, licensure in an abortion prohibitive state may actually present more risk to a provider, because we frequently see that providers are, provider conduct is not occurring in one state, is not a limit to another state considering that. And we also have this specter of the possibility of criminal risk that goes beyond licensing enforcement, which is ordinarily what we, as a telemedicine lawyer, ordinarily the question is, are you complying with the state laws? Are you putting your license as a physician or a pharmacy at risk? But in this case, there may be accusations of unlicensed practice, and there may be cases where states decide to pursue criminal enforcement. So ironically, professionals may have greater rights from permissive states if they're not subject at least to the licensing laws of prohibitive states. I wanted to talk about modalities of telehealth. As I mentioned earlier, in the early days of telehealth, the primary means that we saw for telehealth was, outside of teleradiology or teledermatology, was what we call synchronous telehealth, meaning a real-time video conference. In the last 5 years, we've seen a dramatic expansion of asynchronous telehealth. It is an important access point because it's much easier for a clinician and patient to exchange data and interact with each other if they don't need to be online at the same time. And normally, a lot of this is referred to as store and forward, meaning getting the information, the data that's necessary, forwarding that to the provider. Can these encounters happen asynchronously? In the last several years, we've seen a middle ground open up in many states. And again, this is a state-by-state, condition-by-condition determination that we're going to get to more in our July presentation. But we've seen this middle ground open up where states have expressed some discomfort with a purely asynchronous doctor and patient messaging each other and asked for some interaction to occur by telephone, what we call interactive audio. And generally, the point here is that states want to see doctors and patients establishing relationships and patients having an opportunity to ask questions about treatment. So we're going to go through that, but those are the three modalities generally that we talk about as telemedicine. Historically, states did not consider telemedicine only encounters. And I'm not talking about follow-ups where a doctor and a patient had a prior relationship and then there's a phone call after, like an access line. That question has come up a few times. I'm talking about a situation where the doctor and patient initiate their encounter by telephone. Certain states have allowed it. Certain states have barred it. In the pandemic, many states expanded access because this was the only technology that some patients had. But it is not, in general, it has not been regarded as a necessarily a satisfactory exchange for telemedicine. I wanted to talk about standard of care. Standard of care is really a central question. And the question here is, how much data does a provider need to obtain to justify the treatment, or in this case, a prescription, right? And in the case, Beth already laid out what a clinician needs to know, and the way that standard of care has shifted as a result of the peer-reviewed studies really establishing that various safeguards that used to be thought to be necessary weren't. And that is, by the way, typical of the way standard of care evolves. The fundamental tenet underlying telehealth is that the standard of care does not change. It's the same whether a patient is seen in person or through digital means. The questions are, what data does the provider need? And what exams or tests need to be done, if any? Again, Beth answered the question for us earlier that in this case, it can be done safely without those. And then one interesting emerging issue in the last few years has been, to what extent can a provider rely upon the source of information? Does a provider need an objective piece of information like an image or a lab test, or can they rely on a self-screening subjective report of the patient's condition, right? Which allows for medications, which allows for safety, and also the related question of whether the patient can self-administer the treatment, whether it's a medication or a test. By the way, this came up around COVID testing, and different sort of tests are approved by the FDA to be self-administered if they're OTC, or with somebody from a physician office in other cases. And generally, we encourage providers to think of using the SOAP paradigm, right? Of what subjective information is necessary to meet standard of care? Objective, do you need any outside information, to make essentially the assessment, and then to have a plan of treatment. And the important point here is that telehealth does not alter the standard, and providers essentially have the same scope of practice that they would have in person if they can meet the standard. I wanted to just point out, by the way, that just to reflect on Beth's comments about the studies being done, we had the privilege several years ago to work with a telemedicine provider and Planned Parenthood on the question of oral contraception being prescribed. And in many ways, it's an interesting model where in that case, what really drove change was that there were several ACOG peer-reviewed published studies that showed that women who took oral contraception self-identified the primary contraindication risk of hypertension. They self-identified more accurately than physicians caught it. And that was deemed to be critical to changing that standard of care. So I hope that, I know Beth has been emphasizing the importance of getting telemedicine information out, but I want to really emphasize to the clinical community that the clinical community drives standard of care in its conversations, and that is hopefully a critical outgrowth of publicizing the clinical information. I wanted to say a little bit about the documentation process here, and this is really a place where, again, there's some unusual questions about documentation. In general, every state law requires physicians, clinicians to maintain adequate medical records, which normally means the identity of the provider, the credentials of the provider, the identity of the patient. In the last several years, we've seen a rise in about 20 plus states of a verification requirement for patient identity. That is not a requirement that ever arose in a brick and mortar context, and yet it has become a requirement in telemedicine, states basically saying, we insist that you, telemedical provider, verify who this patient is, by driver's license or otherwise, as a condition of treating patients. It seems to be based on a fear that patients will not accurately say who they are, and that may impair our medical system. Historically, there has never been a requirement to verify a patient's location, and one of the most interesting questions to me is whether this is going to become a priority. And I will talk more about on the next slide about patient location issues. So ordinarily the question is there sufficient contact? Does the doctor or the clinician have enough information to establish a relationship with the patient? Even though in many cases, as in medication abortion, the standards of what data is needed have really been streamlined as a result of the clinical research. It is still, the law still thinks of it as an examination, right? An examination is not just, in many states we use the language prior appropriate examination, in other states a good faith examination. That is not necessarily an in-person event. In a telehealth encounter, the examination is occurring by the digital exchange, and it may simply be an examination of the data, but that is a critical paradigm that applies in brick and mortar, traditional telehealth, as well as in telemedicine. And at a minimum, what it means other than getting the key information from the patient is offering the patient the opportunity to ask questions and to ensure that the patient understands what's happening. There was, I put a bullet on here that I think is very fascinating to me, and I'm going to turn it over to Beth. There's this separate question in telemedicine about concerns of patient privacy and what maybe a provider should consider not asking. Beth, do you want to talk about this, or do you want me to?
So it is important for clinical care that providers obtain and document the information that's necessary to support the care that they're planning to provide. But I think with the abortion context, because of the political and legal situation, clinicians should consider the potential implications of what they document and should avoid documenting things that are not necessary for the clinical care. For example, in the case of abortion, why does this patient want the abortion, or what kinds of actions they might have taken before coming to the clinician to try to induce an abortion. Those things are irrelevant to abortion provision and could have the potential to be used for harassment of the patient or even prosecution. So record what you need to record for the clinical care, but don't add things that aren't necessary. That is the message that we're sort of that needs to be understood now.
Thank you. So I wanted to just, so very important, by the way, interesting question of some telemedicine providers use programs like DoseSpot and SureScript also, which may share information, patient information with other providers. Very interesting question about how to protect patient privacy and to limit who has access to data. As a final point on documentation, actually 2 points. So first, consent to a telehealth, telemedicine encounter used to be a requirement in most states. It's largely, but not entirely, been removed. But there is, in this case, because of the FDA REMS, risk evaluation mitigation strategy, there is a requirement of a prescriber agreement, to prescribe being submitted to the FDA, and also a form of a patient agreement, essentially, which is an informed consent. It's very interesting to look at what the FDA is still requiring in the case of this medication that's really differentiated from most other medications, but it's important to pay attention to those requirements, and we will be putting out additional information on model documentation after this program. So let me just advance. Okay, I want to talk about location. I know there were some questions about this. So originally, so again, there were these archaic terms that you'll still see in many state laws of where the patient is located is referred to as the originating site, and where the provider is located is the distant site. Originally there were requirements years and years ago where patients had to be someplace where there was a significant telecommunications system from which the service administered. But it's interesting. That's a very important point in many states for reimbursement. It hasn't completely gone away. And if you're looking at state laws and you see those terms, it's important to understand that originating site is where the patient is. So, it's very interesting. Again, as I mentioned earlier, there has never been a requirement in telemedicine to verify where the patient is located, even though that is the key determinant. And over the years, in many contexts predating medication abortion, we've had questions about how much can we treat a patient when that patient is moving around, right? It can sometimes be, for example, a person lives in state number 1 and they're temporarily in state number 2. You have cases where people split the year in different places. You have cases where people move for work or for some other travel. You have people going to college, and in general, the rule for people in a case where somebody has, I'm going to talk about 2 different cases here. In a case where a doctor has an existing relationship or a clinician has a relationship with a patient, as I mentioned on the earlier slide, the clinician has performed an appropriate exam, and that exam has a standard of care associated with it of how long the clinician can rely upon it, irrespective of where the patient is, right? And so, for example, if a doctor and patient have a relationship and the patient moves away, if the doctor examined the patient, for example, in the last 6 months, in the last year, and the patient is calling about a condition where the clinician has sufficient information from that past exam, a clinician is permitted to rely upon that for most purposes. If there is a new emergent condition, it always has to be a consideration. Does this patient require emergency care, or should a new exam be performed? And with respect to the question of people moving, that we have many examples where people have a residence in one state, and they might be in a second location in a second state, and then but still choose for telemedicine purposes to contact a provider who's located in that state where they reside. We have never seen any kind of suggestion that a clinician in the state where the person resides should be concerned about treating the patient. If a patient represents to a provider that they live in a particular state, the provider is not required to check and see if the patient really lives there or really lives there right now. There are, again, as I mentioned on the previous slide, verification requirements, but it's very important to note that there has never been a requirement to verify where patients are, right? And so, you know, this is a fascinating question, because when a patient represents where they live, and if they represent to a provider that they live in a permissive state, in our view, a provider is permitted to treat the interaction as occurring in that state. The focus on identity verification has not extended to requiring providers to verify where patients are. And so we'll say more about this, and I think this issue is going to require further attention. But as of this moment, there are no restrictions that limit a doctor to sort of force a patient to prove where they reside, and therefore you could have cases where a patient claims residency in state number 1, even though the patient is in fact located in state number 2, and from a practice of medicine standpoint, a provider in state 1 is permitted to believe the patient and treat the patient. And I'm sure this won't be the last word on that, but I wanted to share that as a perspective of spending the last 15, 20 years dealing with this issue in many cases before state medical boards. So we wanted to take a couple minutes and address the questions that have been asked. And I've opened them. I just opened them up. Beth, I don't know if you can open them up as well. There are some, starting at the top, there are a couple clinical questions. The first one was, can an ectopic pregnancy be determined without a screening? Beth, do you want to take that?
Yeah, that's a good question. The answer is not always, but sometimes. The clinician can ask the patient about risk factors and current symptoms, and that does not always a person could have an ectopic pregnancy and have no risk factors or symptoms. However, a couple of points should be remembered here. One is that ectopic pregnancy seems to be very rare in abortion populations of people seeking abortion. And so the risk of missing one the absolute risk is very low. Secondly, we can treat people with mifepristone and misoprostol who do in fact have an ectopic pregnancy and identify that condition later and take care of it then. In fact, there's been studies of this, studies of patients who are treated without knowing whether the patient does or doesn't have an ectopic pregnancy, and it turns out that treating those patients rather than not treating them and waiting until you can really for sure diagnose an ectopic pregnancy actually is a good idea. And all of the organizations that I mentioned have signed on to this concept. So I think that clinicians need to be aware that through history alone, it's not, they don't 100%, can't 100% determine whether the patient has an ectopic pregnancy, but for clinical, nothing in the world is 100%. And for clinical purposes, this is a good thing, this is good enough, and they should be aware that it's a possibility that they've missed one and manage that after treatment.
So there were a series of questions here on patient locations and patients temporarily in other locations. The first question was, I'm a physician and will often send a medication to a pharmacy while my patient is on vacation in another state. Is this legal in general, and for mifepristone in particular? So, with respect in general, you know, as I was mentioning earlier, we often, if a physician has a patient relationship, the fact that a patient is temporarily in another location is not a barrier to treatment, and it is perfectly within the authorized scope of practice for a physician to refill a prescription, or if they have enough information from their previous exam to prescribe a medication that a patient requires. And in general, we have not seen any concerns from pharmacies with filling those medications in those other states, right? Pharmacies routinely will fill prescriptions from interstate, for interstate purposes. Obviously, there are cases where pharmacies will sometimes raise risk management concerns and want to have more information, but that is generally a legal practice. With regard to mifepristone, I believe that sending mifepristone into a prohibitive state, a hostile state, is probably going to be a risk issue. First of all, I assume that pharmacies in these states may not be stocking it. But I think this is a different answer, because I think this raises a risk issue for the pharmacy, and I expect that pharmacies are not going to be wanting to do that. There was also another question. I live in one state and practice medicine in another. I frequently refill medication requests from my home in a state where I'm not licensed. Is that a consideration for telehealth abortion? So this comes up frequently. Physicians, clinicians often will live in a remote location. It is not in any way a limitation on your living in a remote location if you have a license in the jurisdiction where the patient is, right? And by the way, and I'll add to that, we've had questions come up about whether a patient traveling to a jurisdiction where the clinician is acceptable. That also is that separate. If a patient travels, to a place where the clinician is, or the clinician is licensed, that's also a valid basis upon which a clinician can treat, and it should not be a consideration. The physician's location should not matter. It's really the patient's residence or location. And another question here: how should clinicians think about where our patients are located? Should we provide an address or IP address? So as I mentioned earlier, historically, there's never been a suggestion that clinicians are expected to verify patient addresses. There have been many telemedicine providers that have checked IP addresses, but in many cases that I'm familiar with, telemedicine providers have looked at patient IP addresses for the purpose of verifying which state the patient's in, so that they know what modality of care is permitted. Right? There are some telemedicine providers that geo-fence their particular, and have different versions of their application on their that will be pulled up on the web or in the app store in the smartphone based on where the patient IP address shows. But that is not a requirement that any state imposes on a doctor. The next question was: have you assessed in which states direct-to-patient telehealth models are effectively banned on where a site-to-site model would be possible? Beth, do you have any comment on this, or we're gonna reserve this for the. I think
it would be really useful to, over the coming months, to really figure out things like this on a state-by-state basis. And the situation keeps changing. The legal situation in these states keeps changing, which makes it difficult. But that I think that would be really useful to do.
We're running out of time, so I'm going to just very quickly just comment on the location of the patient of the visit being important for insurance purposes is absolutely a valid issue, and where the pharmacy is located and who dispenses is the issue. So just as a last question, there's a question here: is there really anything at all except aid access for the bad states now? And I think that the answer is that it's going to be very difficult at the moment for anybody who holds a license to help in the hostile states. And I think that organizations like Aid Access are going to be a very important resource. And we are going to be talking more about this in July. I want to shift just to one final slide, just to give Beth the chance to offer some final thoughts today, and to and I have some of my own. And we will, if you asked a question and we didn't address it, we will we'll try to do those after the webinar. I'm sorry that we ran out of time there. Beth, do you have any final thoughts?
No, Harry, you go ahead.
Okay. So I want to thank everybody for tuning in today. I hope this has been helpful. Again, it is a critical moment to put out reliable information about the state of medication abortion and telemedicine and their intersection. The environment is changing very quickly as to where telemedicine is a viable possibility, as to what enforcement actions hostile states may pursue about how much permissive states may protect telemedicine beyond their borders. I hope that we'll take those issues on in our next webinar, and how much policing location will begin to, if that will be a thing that matters in the future. So we are having these two other programs that we mentioned that are currently planned. One for July 20th, which is going to do a deeper dive on the state-by-state questions. For August 17th, we're going to speak about the liability and risks involved. And we are very much welcoming feedback and suggestions. You know, this is a fast-moving situation, and to the extent that we can provide helpful information based on experience with telemedicine, we are absolutely delighted to do that. So please email us after the program if you have thoughts on questions that you think would be valuable for the provider community or more broadly. So with that, I'm going to sign off and thank all of you. I want to thank Beth in particular. It was really a privilege to be able to share information and to draw on your expertise. I hope that this program has been valuable. And I'm going to put up as a final slide how to reach me or to reach Beth. And thank you all for being part of our program today. Thank you.